want compensation. We want the right to actually terminate the contract. And that, again, is a technical issue from your customer organisation's perspective. Again, the lawyers won't know what that threshold is. Your business people may not know what that threshold is, but the IT team certainly will. That if we are getting service levels below this, then this is having a minor impact. If it's below this, we shouldn't be dealing with the service provider. We need to call it quits because there's something seriously wrong going if we've had those amounts of breaches over this amount of period. And again, you need to bear in mind the public and private cloud difference again. If you're trying to go in heavy with public cloud, you're unlikely to get anywhere. Private cloud, you can go in heavy, but you'll probably pay a risk premium for that. So again, you need to weigh all this up. Links us to liability. Again, with liability, have a think. What do you in those different scenarios, what you are looking to outsource, what you're looking to put in the cloud, what are your key areas of concern? What amounts would you be looking to recover? Have in the back of your mind, it is an indemnification, it isn't outsourcing all your risk. You do have insurance, you do have risk mitigation internally, but what are the things, based on what you're paying, based on the importance of the transaction, is it reasonable? And that's the key aspect. What is it reasonable for you to feel that the supplier should pick up the tab for? And again, since that is usually a contentious issue, and if you are going outside what the service provider is offering, so if they're offering 100% of charges on an annual basis, or they're offering a multiplier of 125, and that doesn't do it for yourselves, there's no point having that discussion after you spent months testing everything on a technical, commercial, ticked all the boxes, and you're getting to the nth hour on signing the contract. If it is that important to yourselves, flag it up front to the team so it can go in the tender, that the service provider is on notice when you actually submit your pricing, when you actually submit this is on the basis we are looking for this amount of liability cover. And linked in with that are the concept of what are excluded losses. So if there is a £1 million liability cap, and you're thinking, well, that sounds fine, £1 million for this type of deal, if we get that per year, if these things go wrong, we're comfortable with that. But you need to make sure that the exclusions of liability in the contract aren't going to take all that away from yourselves. And lawyers like to talk about direct losses and indirect losses, and broadly, direct losses are things which naturally arise from that breach. So things as a reasonable person would think, yes, in that breach, I can imagine that party suffering those losses, and those are the losses that we'd like to recover. And usually contracts provide for recovery of those. And then indirect losses are usually excluded. It's common industry practice to do so. And these are losses which aren't direct losses, so there aren't things that you think are obvious that would suffer from the breach, but there are other issues that would have been in the minds of the parties at the time that they actually formed the contract. So if it was critical that you went go live on a particular date, and if you don't go live, that's going to have an impact because you had a massive PR campaign, multi-million pound PR campaign, and that's no good to you now, well, your service provider wouldn't have been aware of that unless you flagged it to them right at the beginning. So these are things which are known as indirect losses. And most suppliers will look to exclude those. And as you can probably sense, and you're probably thinking, well, is that a direct, is that an indirect? Well, lawyers say the same things as so do judges. So what is best practice is to think about those particular losses that you would really like to recover, that you want to be absolutely 100% sure these aren't going to fall within the excluded losses. And they are identified in the contract as deemed recoverable losses, that these losses, irrespective of what the exclusions say, we can recover these. If we have to go out, we have to do another procurement exercise with someone else, we've just wasted a whole load of cost doing that with yourselves. We want to be able to recover all that cost. Now, that could be a direct loss, but if you want to avoid a lot of legal costs, work out whether it is or not, why not just say it up front? And if that's what you're going to be wanting to do, it's going to be a contentious issue for a supplier. A supplier wants to minimize their liability, and if you want to do that, then flag it up front. So at least the supplier has the opportunity to either think, well, that's fine, we can price for it, and you will have that in your pricing, or no, this is too risky for us, we don't want to go ahead, please try someone else, or have a conversation to say, well, what actually are your concerns? And isn't that something you can cover off by insurance or your internal mitigation? And then there's limitation periods. So we've got the amounts, we've got what's excluded, and then we've got limitation periods. And Under contractual law, if there is a breach of a contract, then you have up to 6 years to bring that claim. And again, customer clients often get twitchy on this when supplier clients put in a limitation period. And again, it's another one where sometimes the CIO's rolled out and said, well, do you realise that they're putting a limitation period on your ability to bring a claim? And that's suddenly, oh, well, we don't want that. Well, chances are, if you know about an issue and you want to bring a claim, you'll bring that within a year, most 2 years. So are you really that fussed if there is a limitation period, which is reducing it from 6 years to 2 years? Suppliers will want it in to make sure they've got certainty that they know after this period, we're not going to, if it's a long-term arrangement, we're not going to have issues in year 3 on our charges relating to year 1. And from a customer organisation perspective, unless there's a very good reason you feel otherwise, it is acceptable to have a reduced limitation period to say, well, if we do want to bring a claim, we'll bring it within this time. Because chances are, if you haven't brought it within 2 years, you're probably unlikely to bring it afterwards. Because if the relationship's that bad, you're probably going to have terminated it. But there are scenarios where it can occur that you do want a longer period, but it would be, I would say it's less from the norm, and it's something you need to ever think about if it is something that a supplier is concerned about having a longer limitation period. We've spoken about BC and DR quite a lot today, and from a contractual perspective, you need to be thinking about the scope of what do you want covered under BC and DR. What type of customer involvement is going to be involved in that? Do you want to have a walkthrough? Do you want the plans to be tested? Do you want to be present there when those tests are actually done? And take into account, again, if it's a cloud arrangement, chances are you're going to have very, very strong resistance to that type of thing. We spoke about force majeure not undermining business continuity and disaster recovery. But another important aspect is to make sure that business continuity and disaster recovery does not cover all force majeure. Again, sometimes we've seen it where customer organisations have taken a bit of a, I can only say a lax view, and they take the view that anything which is, you know, beyond our control, beyond your control, we want it covered under BC and DR. Well, you clearly can't do that. BC and DR will be very specific to various events. If you want it covering more than what the supplier is normally covering, and you need to do your due diligence up front, ask the supplier, what are you actually covering in your BC and DR? To what extent are you offering that? What have we got within your price? Does that meet your requirements? If it does, fine. If it doesn't, again, flag to the supplier, well, we have some concerns, and we would like these bits covered in that. Or we are happy to cover it internally, but we need you guys to work with us so we can actually understand what the gap is and how to plug that. The other important aspect is that of term and termination of the contract. You need to be thinking about a cloud arrangement. How long are you actually going into it? Is it a long-term thing? And people think, well, we'll have a short one. We'll have a 12-month rolling. Okay, fine. That means at the end of the 12 months, does a contract end automatically unless it's extended by both parties agreeing it, or do you have to provide a certain amount of notice and then it rolls? The problem with having a short term is that a supplier could then decide, unless the contract says otherwise, well, we don't want to go ahead on this basis. They could hold you to ransom and say, you had an absolutely cracking deal at the beginning because we wanted your business and you got great pricing offers and you really screwed us on the liability. Well done on that one. But now if you want year 2, then we're not obliged to, because it was only a 12-month contract. It was a rolling contract. We needed to do it by agreement. So now, if you want to go into year 2, we want that liability cap reduced. We want the pricing increased. So it's important that you ever think about what kind of term are you looking for. And you could have a long term and then have rights for yourselves to terminate for convenience. So you could say that, you know, if we want to, without you guys being in breach, we've had a better offer elsewhere, we see a better offering somewhere else, we would like to give you a certain amount of notice and just terminate. If there is a termination for convenience, you need to also be thinking about, are there any associated termination costs? So with a public cloud offering, which is very flexible, upscale, downscale quite easily, termination costs are likely to be low, if any. With a private cloud where there's dedicated infrastructure or software, and there's investment costs by the service provider, they need to recoup those costs, whether it's from yourself, the next customer. But there's likely to be a certain period that they actually need to run the contract through with yourselves where it makes it worthwhile them doing that contract. And if they can't get that minimum term, then they'll be looking for a termination cost payment. So going right back to the beginning of what we discussed this morning about, does the cost model stack up? It's not just the price that you're paying on a monthly basis. It's also, what is the indexation? What is the scope for price increases? What is the term and what happens to pricing then? Can we insist that the supplier can't terminate before the end of the term, but we can? And if there is a termination cost, what will that be if we decide we want to pull the plug after a year, after 2 years? And in view of that termination cost, does the model still stack up? Is cloud still for us based on that? Are we still realizing the cost savings that we thought that we were going to achieve? And then, of course, there's termination for breach, and that will usually be linked to service levels. And again, you as an organization, your IT team are best placed to understand which of those critical service levels, if you're getting month on month, week on week, day on day, poor performance, you need to pull the plug. How many goes do you give the service provider? How many warnings do you give them before you need to pull the plug? So again, that needs to be fed into these legal discussions. And you can have other termination rights. So you could have change of control if the supplier is going to be taken over by one of your competitors and become one of their subsidiaries, if that's a concern. You could have termination for benchmarking, for example. You could say, well, we want some benchmarking rights, and there, if you're not competitive, we want to terminate. But you could achieve that through termination for convenience anyway, if the supplier is willing to grant you that right. And then there's the importance of exit assistance. And that's something, again, that's been flagged in the talks today. But you need to be thinking about, if this cloud arrangement came to an end, what assistance would we need from a data migration perspective? Would we need any? Do they just transfer it back? Do we need it back in a particular format? Do we need hand-holding so they can transfer it to another cloud service provider? Do we want to bring it back in-house? That thought process needs to be done up front, because by the time you come to the end of a contract, it depends what's triggered that termination. If it's termination because it's come to an end, then fine, it's an amicable arrangement, but the supplier isn't really incentivized to make sure they go the extra mile because they're not getting any more revenue from you. If it's terminated because of breach, then you guys might not be talking to each other, and then it's going to become a very strained relationship to then be thinking about exit assistance at that stage. So you need to be thinking about those kind of things up front. And another one that customer organisations love to throw in is that on exit assistance, we're happy to pay for it, unless it's a termination for breach. If it's a termination for breach, we're not paying for it. And this is another one for the CIO to be pulled into the meeting room on. And I always find it a bit of a bizarre argument, acting for customer or supplier side, because exit assistance is a service you are going to be getting from the supplier in any event. It terminates at the end of the period. It terminates because there's a breach. Exit assistance is something that you are going to need, and it is a service. Supplier's going to want to charge for that. What difference does it make then, whether it's been terminated because of breach or terminated for convenience, if you're receiving the same service? So that's something, again, just to bear in mind that, you know, and some organisations that are very large do impose certain, you know, they say, well, we only want to be charged at cost because you've now caused us some hassle or whatever. But, you know, again, just going back to if you are looking for a partnering arrangement, and if this is part of the discussions up front, it is reasonable to allow the supplier to charge for exit assistance. If you have a parting of the ways because there's been a termination for breach, you still have your rights and remedies under the contract. You can still sue them for those damages that you are entitled to under the contract. But why should that negate you having to pay anything for exit assistance? Or at the very least, if you don't want to pay them for anything on exit assistance, say to the supplier, we're reasonable people, you can charge us, but we're going to set off against the exit assistance charges, whatever bill you put in, we feel we've got liability of X, we're going to set that off against the exit charges. So at least have some basis for that type of argument if that's what you're going to be putting forward. The other important thing with termination is that at the end of a term, you can plan for it. Termination's coming up in 6 months. It's coming up in 3 months.